1969 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်1 Captain တင်ညွန့် Appellant First The Union of Burma Respondent ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစော်မင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Court Martial Appeal Court Criminal Appeal before ဒေါက်တာမောင်မောင် CJ ခိုးထွန်းတာ and ဦးအောင်ကြီး JJ Captain တင်ညွန့် Appellant First The Union of Burma Respondent Penal Code Section 342 Read with Section 71 Defense Service Act Defense Service Act Section 65 Wrongful Confinement Physical Obstruction not required when the offense is complete. The appellant was convicted under Section 342 Penal Code read with Section 71 of the Defense Service Act and under Section 65 of the later Act. Hell, wrongful confinement as defined by Section 340 Penal Code does not require physical obstruction, but if it is proved that the mind of the person is affected in such a way which reasonably leads him to believe he is restricted and unable to go where he likes without being restrained, the offense is complete. The two policemen were under the instructions of the accused to arrest him, and the complainant was restrained from going somewhere in a sidecar. Wrongful confinement thus started from that point. When the accused arrived and took away Mount Jai, the offense of wrongful confinement continued. For the appellant, Domya Danu, government advocate for the respondent, U Angji, judge, this appeal arises out of a trial by summary general court-martial in which appellant Burma Air Force 1361 Captain Tin Nyunt 501 wing was sentenced under 4 charges. He was convicted on the second and third charges, which related to wrongful confinement of 1 Mount Jai, a goldsmith of Mumbai, and extortion of money from him. He was, however, acquitted of the first and 4 charges of causing harm to this Mount Jai and of being intoxicated on the night he committed the offense. As a result of the 2 findings on the second and third charges, he was sentenced to a forfeiture of 4 years of his past service for purpose of pension and to be severely reprimanded. When the proceedings were sent for confirmation under Section 164 Defense Service Act, the sentence was found to be inadequate and the proceedings were therefore returned for purpose of reconsideration. The original sentence was consequently revoked and the appellant was thereupon sentenced to 5 years forfeiture of his pensions and to be severely reprimanded. Both the conviction and sentence were confirmed by the Vice Chief of Staff on 1st March 1966. The history of this case had its beginning between 2 civilians, one Matway Singh, defendant witness 1, a seamstress and sister-in-law of the accused, and one Mount Jai, plaintiff witness 1, a goldsmith, both of Mumbai, and who lived not far from each other. On or about 11 January 1965, Matway Singh went to Mount Jai with gold weighing nearly 1.2 tickets and asked him to sell it for her. The prevailing rate was about 380 to 400 per ticket, and the gold was therefore worth about 4,000 to 5,000, and Mount Jai was to get 2% commission on the sale. He asked her to convert within an hour, as he was expecting someone who was wanting to buy gold. But this man had not arrived when Matri came again. Instead, one Go Thong Ang, who was once Mount Jai's brother-in-law, happened to come to make enquiries. As he too had a prospective purchaser, Mount Jai suggested to Matri to go along with him. But Matri could not follow because she had duties at home. Go Thong Ang therefore requested Mount Jai to be allowed to take the gold and show it to his prospective purchaser and return by 12 noon. He was allowed, but he did not turn it at the appointed hour. Mount Jai tried to trace him in vain. When Matri came again some days later, Mount Jai could neither return the gold nor give its value. Matri demanded a compensation of 4,000, and when he refused to pay it, she reported to the police. On 18 February 1965, Mount Jai received summons at 5 p.m. to come and be at the police station the next day by 8 a.m. She obeyed the summons, and when he went there at the required hour, he saw a person in uniform, and after he left the police station, Mount Jai was informed by the police station inspector that the person in uniform was a relative of Matri. The police station inspector, U Tin Myint, plaintiff witness 9, asked him if it was true that he had sold a gold comb and bangles for Matri. To this, Mount Jai replied that it was a gold bar she had brought to him, and that he merely waited and Matri sold it. He was kept at the police station till 12 noon, and when re-examined, he repeated his story as in the morning. He was then sent back. On 22 February 1965, at about 8 a.m., Mount Jai was summoned again to the police station, and on his arrival, he was told that Captain Dan La wanted to see him. He was taken in a jeep used by the army, and when he met Captain Dan La, the accused was also present and introduced to him as Captain Tin Nyunt. Captain Dan La then asked Mount Jai if Matri had given him gold for sale. He then replied that a report had been lodged against him at the police station that he had been given a gold comb and bangles for sale, but actually it was a gold bar that he was given to sell. When Captain Dan La received this reply, he said, ဒီလိုဆိုရင်၎င်းကိစ္စကိုသူ့အနေနှင့်ဆုံးဖြတ်မပေးနိုင်တရားရုံးကိုသွားပါ After this, Mount Jai was allowed to return home. On the same day, at about 9 p.m., the elders of the quarter, who knew both Matri and Mount Jai, tried to settle the matter amicably for them. Mount Jai was sent for, and when he arrived at the house of Elder U Tin Ang, defendant witness 2, there were Zhao, plaintiff witnesses, and another elder Wu, not a witness. Besides these elders, Matui and the accused were also present. To put it shortly, the aggrieved party, Matui wanted compensation not less than 4,000, which Mao Jai said he could not pay. Nothing fruitful therefore resulted. It is, however, in the evidence of Wu Zhao that at about 8 a.m. on 23 February 1965, Mao Jai came and requested him to intervene on his behalf that he would be prepared to pay up just 1,500. It was then arranged that all should meet again at 9 p.m. at Wu Tin'ang's house. Matui and the accused arrived in time, but Mao Jai failed to come. In his absence, Matui repeated to the elders that she could not accept less than 4,000. On 24 February 1965, sometime past midnight, while Mao Jai was asleep, he was awakened by loud and hard knocks which were audible even at Wu Zhao's house. A few doors away, somebody also called out Mao Jai's name, but as there was no reply, this late visitor left. Half an hour later, while Mao Jai was still awake, a car arrived at the front of his house, and his name was called out again. As he suspected trouble, he slipped away from the back and went and hid in another house. Later, he went and saw the head of one Wu to take him in his sidecar to the police station. As they were about to leave by a back street, Mao Jai said they were stopped by a policeman who, pointing again at him, ordered him to come forward and reveal his name. When he said he was Mao Jai, he was made to sit down. Later, he saw another policeman, and one of them took out his belt and tied him securely with it. Within 5 minutes or so, the accused arrived and the two policemen informed him that they had arrested Mao Jai. The accused then added words to this effect: "You and I will know each other tonight," after which he delivered Mao Jai a blow, which, upon being avoided, struck him near the right eye. He was made to enter into the death cell brought by the driver. The two policemen got into the rear and Mao Jai sat in the front. Between the accused and driver, Wu Zhao, plaintiff witness 8, on the way towards the airport, Mao Jai said the accused stared at his stomach, something hot, which he thought was a revolver, and asked him whether he would or would not pay up 4,000 to Matui. As he grew afraid, Mao Jai said he would pay up if the body wished him to do so, but that at present he could pay up only about 500 and make it with gold, so that it would total 2,000 and that the balance would be paid in installments. When they arrived at the airport, Mao Jai, who had on only a vest, since he left his house, complained of being cold. The accused therefore went into a building and brought him a warm coat. The car then proceeded towards Tawai Pagoda and stopped near a rubber plantation. It was then, according to policeman Mao Ngai, plaintiff witness 4, about 2 a.m., the accused and Mount Jai alone had a talk and disturbed for about 10 minutes, after which they came back into town, and on arrival at Mount Jai house, he wanted and brought from among his possessions a small amount of cash, of jet 470, a pair of gold anklets, and a gold bar, all of which, including the cash, would come off to jet 2000. They proceeded to Dotway Singh house, and it was about 3 a.m. when they woke her up. A temporary agreement was drawn up by the accused, but which is not an exhibit in the proceeding for, according to driver Ujo, plaintiff witness 3, he was the only Luji on the spot to sign it, beside Mount Jai and Matway Singh. Exhibit 2 was drawn up later and signed again by Mount Jai and Matway Singh, and on the reverse are the signatures of witness Uche, Udin and Ujo. As this Exhibit 2 had no revenue stamp, another document with revenue stamp of Jet 5 was drawn up and signed by the same person who had done so on Exhibit 2. As the accused was acquitted of causing hurt to Mount Jai and of being intoxicated, it will be necessary to deal only with the second and third charges of wrongful confinement and extortion. In his evidence, the accused did not deny taking Mount Jai to the airport, nor did he deny asking the help of 2M police patrol. He however denied taking Mount Jai by force, and that it was Mount Jai who said it was Boji's wish to take him anywhere for a talk by themselves, and that was why he went to Downwine Pagoda near the airport. As regards the money and gold obtained from Mount Jai, the accused explained in his evidence that Mount Jai volunteered to pay Jet 2000 as desired by Matway Singh, stating, however, that he could pay on that night only some cash and gold to total Jet 2000. The accused also admitted that when they returned into town, a temporary document was executed at Matway Singh house and later finalized in Exhibit 1, which had a revenue stamp of Jet 5. At about 9 p.m. on 25 February 1965, the accused said he was present when the three elders met Mount Jai, who came to pay the balance of Jet 1,530 to total Jet 2,000, due as the first installment. Matway Singh then returned to Mount Jai, his gold bar and the pair of anklets. As stated earlier, this matter was nearly between two civilians, and the accused came into it because Matway Singh, the aggrieved party, was his sister-in-law, being a cousin of his wife, Dokin Nui. Hitherto, before he took the matter solely into his own hands, Mount Jai had been available either through the police station inspector, Captain Danla, or through the goods officer of the three elders whose names are found in Exhibit 2. On the night in question, when he was in search of Mount Jai, he met Ujo, who in his evidence said the accused made of liquor. This elderly gentleman gave him advice, saying, Boji, nene ro nyine dwa bi, nene ja ma la ba. But the accused could not be prevailed upon and with the help of 2M police patrol, he managed to block the points of entry and exit to Mount Jai house, with the result that Mount Jai, while trying to escape with the sidecar, was caught by one of the policemen and, as already described and admitted by the accused, Mount Jai was taken away in a death sentence several miles out of town, arriving downwind by 2 a.m. Wrongful confinement as defined by Section 340 Penal Code does not require physical obstruction, but if it is proved that the mind of the person is affected in such a way which reasonably leads him to believe he is restricted and unable to go where he likes without being restrained, the offense is complete. The two policemen, Mount Ngai and Mount Chit, plaintiff witnesses 4 and 5, were admittedly under the instructions of the accused to arrest him. It is to their interest to deny that Mount Jai was tied up, but they at least admitted restraining Mount Jai, going somewhere in a sidecar. Wrongful confinement thus started from that point. When the accused arrived and took away Mount Jai, the offense of wrongful confinement continued. There is no reason why the accused, as advised by Wu Zhuozhou, could not postpone till the next day. Captain Tan La had said on 22 February 1965 that the matter should go before a court of law, and on the night of 23 January 1965, when Mount Jai failed to turn it to Wu Tin'ang house to settle the matter as promised, the three elders told Matui Singh and the accused to take the matter before a court of law, to have taken the matter into his own hands, as described, was plainly therefore wrongful confinement of Mount Jai. As regards the charge of extortion, it has to be remembered that Mount Jai was not free from blame. He owed Matui Singh the value of her gold because he took the responsibility by accepting her gold bar for sale, and the fact that he may have been cheated by Go Thong Ang did not lessen his responsibility. He made various statements which he later admitted to be untrue, and in these circumstances, his allegation that money was obtained from him by extortion must be regarded with caution. On the other hand, it is highly probable that, while under wrongful confinement, he promised to discharge his obligation with whatever he had at the material time and to make up the balance later. We are therefore of opinion that extortion has not been proved beyond reasonable doubt. Nevertheless, in our view, the accused had behaved in a manner unbecoming of an officer of the defense service, especially in this time, when the service are being built into a Pidu Tamato. The Lenin government advocate submit that what the accused had done fell within the ambit of Section 65 of the Defense Service Act, and we agree. For reasons we have given, we would maintain the conviction under Section 342 Penal Code, read with Section 71 of the Defense Service Act, but we would set aside the conviction under Section 52A of the Defense Service Act, and in lieu thereof, we would substitute a conviction under Section 65 of the Defense Service Act and maintain the sentence of forfeiture and the severe reprimand passed upon the accused and dismiss this appeal.